Good morning, ladies and gentlemen, and a very warm welcome to this special webinar entitled The One-Year Unwanted Anniversary of COVID-19 Restrictions, Reviewing the 2020 Lockdown and Seeking a Balance of Rights. My name is Janelle Mangwanda, a researcher at Africa Criminal Justice Reform, and I will facilitate today's discussion. It was exactly a year ago today when South Africa entered what we all thought would be a 3-week lockdown and life would return to normal. However, as the title of our webinar suggests, here we are, a year later. COVID-19 is still amongst us. Many have lost their lives, others have lost friends and family, and every sphere of life as we know it has been affected. Interestingly, since the onset of the pandemic, at least 17 African countries declared states of emergencies, 8 declared states of disasters, and 10 declared public health emergencies. South Africa is one of the countries that declared a state of disaster. And while the state of disaster was originally set to lapse on the 15th of June, 3 months after it came into effect, the law provides that it may be extended by the Minister of Cooperative Governance and Traditional Affairs for a month at a time before it lapses. This means that since June 2020, the state of disaster has been extended at least 9 times. As we all know, the country has gone from a hard lockdown, level 5, to a series of adjusted levels, of which we currently stand at level 1. Today's webinar is particularly special, not only because it is an unwanted anniversary, but also because it is important to review the lockdown and whether or not there has been a balancing of rights. We have had numerous family meetings or family gatherings, as they have been called every time our president addresses the nation regarding the lockdown. And I think that it's important for us to have a family meeting of our own. As academics, as civil society organizations, as public health experts, as well as ordinary citizens. We need to speak about the various aspects, such as the rights that were restricted, and whether these had clear public health objectives, and the effects that it had on both the physical and mental health of citizens, and whether criminal justice should have been used to inform a public health crisis. Furthermore, we need to also speak about the victims, as well as vulnerable groups such as prisoners who also face the scourge of COVID-19 in the government's response. These are some hard and difficult conversations to have, and fortunately, I am only facilitating this morning's sessions, and we have 4 expert panelists that will drive today's family meeting. Firstly, we have Professor Nico Steytler, who is the Saatchi Chair in Multi-Level Government, Law and Policy. He's the former director of the Community Law Center, or what is currently known as the Dalla Omar Institute. We also have Dr. Leandri Hattingh, who is a medical doctor with a decade of experience in managed healthcare. She formalized her knowledge with master's degrees in applied ethics and public mental health. Thirdly, we have Dr. Jean Redpath, a senior researcher at Africa Criminal Justice Reform. She holds a PhD in law from the University of the Western Cape. Last but not least, we have Professor Lukas Muntingh, project head of ACJR, who holds a PhD in law from UWC and a master's degree in sociology from Stellenbosch University. He has also been involved in criminal justice reform since 1992. Both Lukas and Jean will provide perspectives on the criminal justice system. We look forward to having an informative and intriguing discussion today with our panelists. Our program today is as follows. We will first have inputs from each panelist, and this will then be followed by a question and answer session. I would like to remind us of our house rules. Firstly, we use Chatham House rules, which means that speakers are only to be quoted on condition that permission is obtained. Secondly, we encourage all participants to make use of the chat box to pose questions and comments, as we will not be taking any voice inputs today. With that said, I would like to welcome our first speaker, our first panelist for today, Professor Steytler, to take the floor.
Good morning, and what a strange, unwanted anniversary is this. You don't celebrate this, you moan it, but perhaps we should also be thankful that um, we are still around a year later. And we said we've lost loved ones and friends and colleagues along the way. Just initial bit of apology for you. As part of the lockdown, a lot of people added to the family by getting a dog for company, and I've still got a young dog of 6 months, so it may bark or not bark, but just bear with me and the dog. So what I want to talk and was asked to talk is what has been the legal and constitutional framework in which the lockdown occurred, and whether this constitutional framework, which we've all lauded as a great constitution, has actually been able to assert some limitations on the conduct of government in how they handled the pandemic, the measures taken. So the question that I want to address is what is then the constitutional framework for governance during the year? And did it impose any constraints on government? And I think it's important that we look at these questions carefully because we are a year in, 3 months into this year, and it could be very well that be by the end of this, that we will still be in some form of a declaration of a state of disaster by the end of the year. The whole process of the distribution of vaccines are still coming, and that will also raise a lot of legal issues, constitutional issues about equality, about how the right to health care, health services are going to come into play. So the first question is, what was the main objectives of all the measures that government has taken? And something that Janelle already referred to, obviously the principal object is to address the health threat and to address the victims of COVID. So it was a health measure, and then number of measures taken to help those who are ill, whole point of saving lives, and then the second measures or set of measures was then how to prevent the spread of COVID, both the international spread, closing of international borders, and then the community spreading. And what was then fairly quickly predicted, all these preventive measures had then created incredible hardship in terms of livelihoods. And so it was the objective of measures to ameliorate the negative consequences of those measures, the loss of livelihoods. And just to start off with, in terms of the Constitution, on what basis could the national government, in fact, govern in this area? Because as we know, health service, disaster management, education, and so on are, in fact, concurrent functions. The national government and the provincial government has got equal say on these measures. And so it was fairly simple for the straightforward for the national government to say, well, we're exercising our powers in these concurrent areas, and not necessarily to the exclusion of provinces, but provinces simply didn't say, well, we want to do something different. We will follow the lead. So no legislation came from the provinces that would be anything different from what came from national. Now, the main concern in the past year has been then the so-called preventive measures. How can the government be able to limit the spread of the virus through various lockdown measures? And these lockdown measures obviously implicate a range of rights. And here is then the focus of our talk this morning is, how did the government manage the limitation of rights during the past year? So if you look at the measures, the first set is then the stay-at-home orders. A year ago, it was the closure of the doors. No one could go out, only to buy essential food and medicines and so on. So the total closure. So right to freedom, Section 21 is quite explicit with what we understand about right to freedom. It talks about freedom of movement, so that was limited. But one should immediately also point out that this was a moving picture. The whole point of governance through the traffic light system, as is known across the world, this is a common way that COVID was addressed, is that you have moved from level 5 to 1, and you can go up again. So it's a constant change in how much of the right to freedom of movement has been infringed. The right to leave the Republic, that's a citizen's right, or resident's right, that was restricted. And then also the citizen's right to reside anywhere in the Republic. A year ago, we could not move out of your municipality or your province. And then the stay-at-home order also meant learners couldn't go to school. They were restricted, and the academic year was saved in some way. But it was the basic right to education said, well, it's suspended until the necessary safety measures has been taken, that schools could reopen. Then linked to the stay-at-home orders, when you could get out, when the stay-at-home orders moved to lower levels, there was then a right of assembly. It's a general right. There's no limitations on the numbers, so we get the numbers being placed on how large an assembly was. The same with the right of association. Again, numbers, permission, all these rights that is unqualified in the Constitution was then severely qualified. And also the right to religion, which again is linked to assembly, the numbers that could attend any religious ceremony, burials, what was then very important, and how the numbers, again, from very restricted to large numbers, and then again down. And so the big question that we learn more about is on Sunday, is what are the restrictions on religious ceremonies over Easter weekend. Then of more also affected by the stay-at-home orders was limits on economic activity. Certain trades couldn't, you may choose to be in a certain trade, and if that trade is not essential service, you had to close shop. Certain trades were not allowed to occupy because of COVID problems. So there is a right that was affected, although that right in terms of Section 22 could be readily limited by regulation. And then what one also should not miss is that many assumptions of measures of, say, homeschooling or university schooling came in that it really infringed the right to equality. And the equality here in Section 9.2 includes full and equal enjoyment of all rights and freedoms. So the right to education certainly becomes dependent on whether you've got access to laptop and data. So what we saw was, again, the widening of the inequality gap in South Africa, contrary to the very firm commitment that the Constitution makes towards equality. Now, what were the constitutional options? And it's good to pause about it, because, as Janelle say, a number of African countries adopted a particular way of dealing with it through states of emergency. So there were two options for the South African government. The one is to declare a state of emergency. In terms of Section 37, that could be done when the life of the nation is threatened by war, invasion, general insurrection, disorder, natural disaster, or other public emergency. So clearly, the pandemic would have qualified as a public emergency. There would have been, if you use this state of emergency, given our past history, there were checks and balances built into the system. Parliamentary approval for so many a length of time, etc. And the other one was simply to say we'll exercise powers that may limit rights because, and then rely on Section 36 of the Constitution that allows for limitations. And that could have been done, the limitations, through a general declaration of a state of disaster. And yeah, you would then have to justify through the state of disaster and the regulations taken under it, whether looking at the nature of the right be infringed, all those factors that have to be taken account when you apply a Section 36 limitation. So no state of emergency was declared, but use was then made of the Disaster Management Act of 2002. And this declaration then enables the minister responsible for the act, and that's the Minister of Cooperative Government, to issue regulations. And there are numerous sets of regulations that you've all encountered, that you all felt, that you thought are totally crazy, are unnecessary, are hard to comply with. Those within the range of measures, mostly in order to stop the spread. So these are mostly preventive measures that we saw coming through the regulations. And then the question is, what are the limits to these regulations? Were there still constitutional limitations also within the statute that would provide a framework in terms of which the government had to provide or could make these regulations and limit rights? As Janelle told us, the first one was a 3-month. We were all expecting the 3-week. Became 5 weeks, and then in the end 3 months, and then every month extension, and this was then extended since June. So it goes on and on and on, and we will hear again. I think it's whether there will be a new declaration or just simply an increase in regulations on the 26th. But it is then an annual, a monthly extension. What was important was that there were no formal role for Parliament in this process. No approval of the extension, which would have been the case under the state of emergency. Parliament, of course, in its general capacity as overseeing the actions of the executive, could make known its views, but it did not depend on Parliament whether we continue with the state of emergency. So when any regulation in terms of the Management Disaster Management Act was a legislative act, therefore had to respect rights, but at the same time, those rights could be limited in terms of Section 36. Then one of, or any of these actions of government, publishing of a regulation, were also subject to what we called a legality review of executive actions. These executive actions are not administrative actions, but a much lower level of scrutiny, which asks for only whether it's rational. And I'll get back to that when we look at some few court cases. And then more recently, a decision coming through that the issuing of regulations are also subject to PAJA, the Promotion of Administrative Justice Act. And so there is a easier way and much more scrutiny in the in this latter form of review. Now, the question then moves to, yes, we have Section 36, the Bill of Rights, we have Section 36. Who checks whether, in fact, the rules and the ones that we thought were crazy or didn't make sense, even government admitted at times that this wasn't a great regulation and that it changed. How could these limitations that's there in the structure of the Constitution be enforced? And the first one is, of course, political enforcement, scrutiny by Parliament. And as we've seen, Parliament has done some of it. There's no direct requirement that it must approve for extension of a state of disaster, but the committees of Parliament certainly may look at regulations, question them. So there is a opinion that Parliament was not forthcoming at particularly beginning stages with any real scrutiny, and that since then it has not been performing its task as the overseer of the executive with great acclaim, dealing with the very practical matters of how you manage a pandemic of this nature. Then, of course, there are the Section 10 institutions that also looks at the constitutionality and good governance, South African Human Rights Commission and the Public Protector. The Human Rights Commission engaged on sometimes, but didn't play a prominent role, as did the Public Protector. Which then leaves us with the courts. Did they perform a valuable role in this regard? And on what basis could they review the regulations and conducts in terms of those regulations? The first basis on which to intervene was to say, well, these regulations were contrary to it wasn't protected by Section 36. The rights involved was not justifiably limited. And there was only one decision called De Beer, where Judge Davis in Gauteng High Court found the number of restrictions were irrational. And if they were irrational, then they were therefore also not reasonable and justifiable limitations under Section 36. So the only decision that running against government was that one. It went on appeal, but became moot before the appeal was heard because the regulations simply changed. The second ground is to say that regulation is done in, regulation could be reviewed in terms of legality. It's the rule of law, and it's a weak review because it only looks at irrationality, and that it's not a reasonable test, it's simply a rationality test. And the DA, right at the beginning, sought to either declare the whole DMA and the measures taken up as unconstitutional, and they couldn't get access to the Constitutional Court because there was no merit in it. Then you have the case of ESO here in the Western Cape. It really went about the role of the National Coronavirus Command Council, whether this institution was government acting through this institution. It was ad hoc, was undermining the very decision-making structure in terms of the Constitution, but the court said no, it is simply a committee of cabinet, and therefore could make those decisions. And now, in any case, this council contains all the members of cabinet, so it's basically cabinet. The other notable case was the Fair Trade Independent Tobacco Association Institute. The tobacco, it was unsuccessfully challenged because government or the court found that there was some rational link between the ban on tobacco and the aim of reducing health care or the need for health care for persons smoking. A more recent an important decision is the appeal against ESO that was a judgment given by the Supreme Court of Appeal in January this year, which says that these regulations are administrative actions, so that the review is reasonableness and also includes procedural fairness. And for example, the public was given 48 hours to comment on certain draft regulations, and the court said, well, because of the urgency, 48 hours was sufficient. But it really opens up the review of regulations much more broadly than previously was possible under the legality review. One should also note the difficulty which courts operate and the usefulness of litigation, because very soon a case simply becomes moot. The regulation under attack was simply removed or changed monthly, and so it's not a permanent regulation, and therefore the court case can easily fall aside. And also one should remember that, and this is a trend across the world, is that courts are not going to readily second guess the national government. Lives are at stake, livelihoods are at stake. The courts will be very loathsome to say, we are in better position to say that this is irrational, this is not acceptable, this is not reasonable. Obviously, in egregious cases, they will do so. But it is not something that they readily would do. Conclusion, as we going to continue with this, with the battling the pandemic, the difficult policy issues will be lives versus livelihoods, and how manage that balance. Obviously, will also be a weighing of rights, and there's no clear guide where the balance should lie. It's a policy matter, but we can guard against irrationality and now also against unreasonableness and disproportionality in terms of budget review. What's also key is that the constitutional principle of transparency must, in fact, be emphasized and enforced, so that we know how the plan and program for spreading vaccinations are done. So one can say, well, this is a public issue, should have information about it, have debate on it, and make rational choices there. And lastly, inequality remains a key issue. Does this way we're handling the pandemic, does it increase or decrease inequality? And that should be foremost in our mind. Thank you.
Thank you very much, Professor Steytler. I think you've made a lot of important and interesting points, and I think some of these ideas will be carried throughout the course of our discussions this morning. I want us to go to Dr. Leandri Hattingh, who will give us a more health or public health perspective on the impact of the lockdown, the virus, as well as all the other elements that come along with this one-year anniversary. Dr. Hattingh.
Thanks for the opportunity. I'm just going to share my screen. Morning, everyone. Yeah, I'd like to try and give you a bit of a perspective from a public health and ethics point of view. So just starting with the definition, a pandemic is simply a worldwide spread of a disease. And the severity of the disease and the way in which it spreads obviously predicts its impact and needs to inform the public health response. And with infectious disease pandemics, the way in which it spreads is directly influenced by people's behavior. The more ubiquitous the spread, the easier the pandemic grows, and the more restrictive the interventions may have to be. And in the case of respiratory diseases such as COVID-19, the simple act of breathing could pose a risk to others, and preventative measures may eventually extend to extremes of curtailing behaviors that we consider as normal acts of living and being human. So we are faced with the question around how we should navigate the conflicting demands between various human needs and rights during a pandemic. And I think one of the things we need to recognize is that most people are wired to look out for themselves, and consider others after themselves. But we are all very much dependent on complex societies, and sometimes we have to make sacrifices for the greater good in order for society to function. So the question becomes, what is reasonable? What kind of sacrifices are reasonable from individuals for the sake of society? And this dial lies somewhere between complete disregard for others and complete martyrdom. And exactly where this dial lies becomes a central question. We can look to several moral theories to try and help answer that question. We can consider the Rawlsian idea of being behind a veil of ignorance, and that forces us to consider what we would think is fair and just in a society if we were at the bottom of the pecking order. And this is a way of trying to protect the vulnerable when we decide about general rules in our society. Utilitarianism is a principle that is often used in public health decision making, and basically this comes down to trying to maximize benefit and minimizing harm for the greatest number of people. We can also consider human rights ethics, and the other panelists are much more qualified than I am to talk about the legal aspects around this, but from an ethics point of view, we also consider human rights, and these are also basically rules that protect individuals in society against the claims of society when their interests are contradictory. and it assigns basic minimum entitlements to everybody equally in society. In most of our modern democracies across the world, individual liberty is very much valued, and it's embedded in constitutional rights. And extending that to the healthcare space in modern Western medicine, the idea of patient autonomy and self-determination is also very highly valued. Essentially, we agree that people should have autonomy and be able to decide what happens to their own bodies and health. And it's essentially a libertarian view, which again in our societies extends to freedoms of trade and association movement and so on, as Nico has already spoken about. So again, the question is, to what extent can we curtail these freedoms and liberties that are so embedded in our modern societies with the objective to protect the greater collective. So I think it's important to consider that when we start weighing rights and entitlements, it can easily become quite an academic abstract exercise. But it's important to remember that each of these rights, especially the very basic constitutional ones, are very much intricately linked to our well-being and our individual flourishing. And in the absence of having these rights protected, we might suffer significant harm. And I think this is something that got lost a little bit in the original discourse, when lockdown started. People seemed to be quite unfazed by the fact that some of their very, very, very basic rights had just suddenly been taken away. And I think it's important to realize how important these rights are to our well-being and really making our lives worth living. So again, as Nico has already explained, several of our freedoms and liberties were very suddenly impaired, and we also had to consider the right to life. On the one side, people with COVID-19 being threatened by death from the disease, but on the other side, people who were facing hunger and possibly even death because of malnourishment, because of lockdown restrictions. And then also a right to healthcare, right to education, right to privacy. All of these things suddenly became threatened by the situation. So there's an important question, and that is which of these rights are more important than others? Which ones trump others? And the immediate reaction might be to say that the right to life is sacrosanct, and that trumps all other rights. But we need to question whether that is really true. So if we look at an example in the healthcare space, and we place the right to life against the right to bodily integrity or autonomy, we can consider that taking a nasal swab to test for COVID without a person's consent, or maybe even putting someone into forced quarantine, or maybe even forcing vaccination if the vaccination is shown to be safe. We can argue that these are justifiably small infringements on individual rights. And if we think in a utilitarian manner about it, we can say that on balance, the harm to a few individuals is far outweighed by the benefits to the greater society, if that helps us contain a dangerous disease. But if we consider the same question in a different example, such as kidney donation, most of us would agree that it's morally unacceptable to force someone to donate their organs, even if it could save someone else's life. Why do we consider this to be too extreme? It seems to expose an innate appreciation that life is actually not, the right to life is not sacrosanct. There are certain boundaries around an individual's self-determination and bodily integrity that we're not prepared to cross, even if it comes at the cost of another life. So where do these boundaries lie? So we can argue that kidney donation is a highly invasive procedure. It carries significant risk to the unwilling donor. If the donor eventually becomes ill later in life, has kidney failure of the other kidney for some reason, we could say that it's a life for a life. But in truth, the risks are actually small. And even the immediate surgical risks of major surgical procedure is a risk that many people accept every day. So it seems that we are more concerned with the permanence of the impact, the fact that the unwilling donor will never regrow a second kidney. And it seems that the harm of the procedure in this case is uncertain in its significance, but it's indefinite and it's irreversible. And that seems to be a line that we are not willing to cross. The fact of the matter is that we attach significant value to our authority over our own bodies. In the absence of that, we can imagine that our individual flourishing and well-being might be significantly, maybe intolerably impaired. And we insist on protecting this authority over our own bodies, and even if that means that someone else might die because we didn't give them our kidney. So it does seem that it is a fallacy to view the right as a life, the right to life as an end in itself, and to say that we can't compare it to other rights which contribute to human flourishing and well-being. And I think perhaps this dichotomy of lives versus livelihood can actually be counterproductive, because immediately there's an appeal to the argument or the idea that the right to life trumps everything else. And it might be more useful, again, to consider the human flourishing on one side of the scale versus human flourishing on the other side of the scale. In the kidney example, it would mean it's the right to life for the kidney recipient, and for the unwilling donor, it is represented by the right to bodily integrity and autonomy. But it ultimately comes down to comparing flourishing and well-being and lives worth living on both sides of the scale. It's obvious that for the deceased, there can be no flourishing, but we do seem to have a threshold of what's reasonable impairment of an individual's flourishing for the sake of others. The terms of the violation of these individual rights need to be dictated by a very nuanced weighing of benefits and harms. And I think it's important that we must consider the cumulative extent and the duration and the reversibility of the consequences of impairing someone's individual rights. If it's irreversible, it seems that sort of line we're not prepared to cross. So returning to COVID-19 and infectious diseases, a major part of the global population was confined at some point. And the sort of some effect of people's individual rights being curtailed for billions of people meant that these lockdowns had to be finite. They couldn't continue indefinitely, but unfortunately, as we see in many cases, they still are. And the point is that the longer it continues, the more severe and intolerable the cumulative harm may become, and there might come a point where this harm becomes irreversible. So if it were 3 days, it would have been fine. I don't think anybody would have complained about that. But if we're looking at being in lockdown for 3 years, the balance starts shifting towards irreversible and intolerable harm for billions of people. So again, the dial of reasonability lies somewhere in between. And it also shifts based on the context and the availability of the mitigations of harm. So in the COVID-19 example, this would have entailed financial stipends and psychological support, education alternatives, and so on for people under COVID-19 lockdown. If you've got those things in place, then you might be able to extend your lockdown for a longer period of time. So the problem with utilitarian type of decision making in public health, even though it's often used, is that it comes down to a weighing of benefits and harms, and in some way you have to predict the consequences of your decisions, and that's very difficult when there's a lot of uncertainty and imperfect information, as we saw with COVID-19. And with any sort of new disease that causes a pandemic, the knowledge always comes in retrospect. And it made sense to be careful and err on the side of caution as our knowledge started growing and the disease started unfolding. But it is also imperative that we constantly readjust our assessment of risk as we understood the disease better, especially considering the extreme harm associated with the public health interventions that we put in place. We needed to constantly readjust our assessment of risk on both sides of the scale, on the side of the risk of infection and on the side of the consequences of our interventions. So just quickly looking and considering the sort of victims of the past year. They were victims of the virus and they were victims of the lockdown. So the infected were obviously subject to stigma, the fear of dying, fear of long-term consequences from the illness, the fear of infecting others. Healthcare workers and healthcare workers were also subject to all of those things, but also faced extreme physical and mental exhaustion and were facing overwhelming and unprecedented onslaught of people dying and severe illness. If we think about victims of the lockdown, people with COVID-19 were also affected by the lockdown, obviously. Many people died alone, people suffered alone. There was the possibility of being charged with criminal charges if you were to infect other people. People with other illnesses suddenly had a drastic reduction in access to healthcare for things like TB and cancer and other chronic illnesses, HIV, mental illness, substance use disorders. And then there were the obvious financial losses across the economic spectrum, with a sort of exponential knock-on effect on people, again, at the bottom of the food chain. Growing inequality in our society, lack of opportunity, education, and a sort of knock-on effect on the socioeconomic status of society. And then everyone was suddenly severed from very fundamental rights and liberties. Many people were subject to fear of becoming, being locked up in prison for doing something that in February 2020 was considered completely normal, like hugging your grandmother, or walking your dog, or buying a pair of socks in the supermarket. And everybody was suddenly subjected to extreme psychological stressors. And then for some, I think there was also an increasing distrust in the state's intention and capability to ensure and protect the well-being of the citizens, especially as the reports of corruption started coming to light. So I just want to quickly talk a little bit about the lockdown's effect on other illnesses. So as I've mentioned, it stretches across the board, and I think for the next few years, we are definitely going to see the negative consequences of this on overall healthcare and healthcare outcomes. I'm not going to spend too much time on the statistics, but basically there was a drastic decrease in primary care health access, surgeries, immunizations, even in the private sector. Again, much less screening for serious illnesses, huge decline in treatment for depression, GP consultations for chronic illnesses, and also HIV care and TB care was severely affected in our country, and the WHO predicted that if there had been a 6-month disruption in antiretroviral treatment, it could result in 500,000 additional deaths from AIDS-related illness in 2021 worldwide. So I think tuberculosis is a specific issue, especially in our country, that we need to consider in the context of COVID and lockdown. As you can see, the deaths for TB just in the year 2019 surpassed the number of deaths for COVID up to date. There's been drastic decline in TB testing and treatment during lockdown periods. And a big contributor to this was not so much that the healthcare services were redirected to COVID, but more because people were scared to go to clinics, and they were scared of the police, and they were restricted in their movement. And so that directly affected their access to TB treatment. And again, WHO predicts, astounding numbers of additional deaths because of lack of TB treatment, even just for a period of 3 months. I'll skip this. Then I want to just quickly talk about the mental health consequences, which I think will be an enormous challenge in the years to come in our country, but worldwide. Mental health was a growing problem in South Africa even before COVID-19. And I think just with the unprecedented stressors that the past year has brought, I think we can expect huge challenges in this space in the years to come. Suddenly people were deprived of usual coping strategies and mental health strategies, such as socializing or exercising or doing things that they enjoy, accessing support groups. And it was worrying to see how these things were being trivialized. In some cases, exercise can be as good as taking an antidepressant for people suffering from depression. And I think this is a problem of Western medicine, that we medicalize things and we underappreciate the value of these basic strategies in maintaining mental health. As I mentioned, sudden severe stressors, and then lockdown has been shown to have significantly detrimental effects on people's mental health, even just after a period of 3 weeks. So increased anxiety, depression, insomnia, post-traumatic stress, and suicide. And I just want to show also that, I'll skip this in the interest of time, but mental health really has knock-on effects in society. It leads to reduced productivity in the workplace, reduced overall health, increases the healthcare burden, substance use problems, contributes to dysfunctional family units and communities, and impairs educational and childhood development. And these things have knock-on effects as well. Again, it has an effect on the economy, morbidity and mortality. It puts additional strain on the healthcare resources in the country. Substance abuse is a direct link to increased crime, road accidents, and interpersonal violence, gender-based violence, and then the effect on education may lead to a cycle of deepening poverty and diminished economic opportunity. So again, it's part of a cycle of problems, and then COVID-19 just knocks all of these aspects along the way as well. And if we look at solutions, we need to address each of these issues separately, but definitely mental health needs to be a very specific focus. So just finally looking back, taking lessons from how we could approach our public health decision making in the future with pandemics like these. It's important for us to consider harms and benefits and try and predict when we make our utilitarian evaluation for our decisions. But we also need to consider the probability of harms and benefits happening. And in COVID-19, the confinement and the lockdown had much more of a risk of causing very severe socioeconomic effects in countries, in developing countries, than it would have had in developed countries with more resources. And I think this also highlights again the importance of considering the context of the pandemic. It's important to realize the global determinants of health and human flourishing. Everything is interconnected. Health is connected to socioeconomic conditions in the country, the environment, to culture, and so on. And I think it was important for international health advisory bodies to provide context-specific guidance to member states. And I think the WHO was perhaps a bit slow in doing that initially. And then there's also a strong case to be made for an interdisciplinary approach to complex problems such as these. Public health advisory shouldn't just be based on epidemiology and infectious disease knowledge. It should also include representatives for law and ethics and behavioral science and psychology and education and so on. And I think that helps bring important perspectives to the table to more accurately predict harms and benefits and make better decisions. So finally, obviously the guidance also needs to be evidence-based, but it needs to be agile. As new evidence comes to the fore, the advice needs to be adjusted, and it needs to be clear so that people can understand it and it can be communicated widely. So to conclude, infectious disease pandemics force individuals and society to reevaluate their perspectives on responsibility and freedom. Utilitarianism is a very important strategy in guiding public health interventions, but these deliberations need to be nuanced and they need to account for broad contextual assessments of harm, benefit, the cumulative impact, duration, complexity, and reversibility of the decisions. And sober decision-making should recognize the value of human flourishing and its intricate dependencies on human rights and liberties. Suffering from the consequences of the lockdown should be equally recognized as the suffering from viral infection, and there needs to be mitigations for both kinds of suffering going forward. Thanks.
Wow, thank you so much, Dr. Hattingh. I think you've given us so much to chew on, and to have a public health or a medical perspective on this and to shed light on how this really does balance between lives and livelihoods. I think it was a very important input. And at this juncture, I'd like to encourage our viewers, our participants to pose questions or comments in the chat box. As we indicated earlier on, we will have a Q&A session at the end of our webinar, but as you are hearing, as you are thinking and questioning, please feel free to pose your questions in the meantime. We are then going to move right along to Dr. Jean Redpath, who will give us another perspective. Jean?
Thanks, Janelle, and thanks to both the previous speakers who have given a great introduction to my presentation, which focuses more on the impact on the criminal justice system and the use of criminal justice system processes as a public health intervention. And I'm just going to share my screen here. And I think what we're asking here is this a limit of criminalization? And how did it actually play out in what has been pointed out as a developing country context, which has serious issues, not only in terms of socioeconomics and inequality, but also in terms of how the police and the enforcers of the law operate in our society. And this comes from our work on offences in Africa, where we have had a long-term campaign as ACJR, looking at the impact that detaining people, arresting and detaining people has on people's rights. And this is particularly in the context of lesser offences such as vagrancy, offences which have particular aims in society, such as many countries will resort to criminalization as an easy way of addressing a problem. Many countries in Africa will criminalize, for example, selling coal on the side of the street in an attempt to protect the trees in their country. But that ends up having many very poor people incarcerated and causing lots of harm and suffering. And so there are two kinds of rights. We have in international law, we look at civil and political rights, and we also look at economic, social, and cultural rights. And this is the lens through which our argument on these offences has been developed. And the pre-trial and fair trial rights, that no one shall be deprived of liberty except on grounds in accordance with procedure as are established by law. And so that's the requirement, that any regulations on which people be detained has to be legalized. That's why our Command Council had to actually pass laws creating offences. And then we also have the rule that persons awaiting trial should not be detained in custody. That should not be the rule. It should only be the exception, and that proceedings must go without delay. And then when we look at socioeconomic rights, which South Africa is a signatory to the convention, and here we have the right to work, the right to just conditions of employment, the duty of the state to provide the widest possible protection to the family, and very important in our context, the right to an adequate standard of living and to be free from hunger, the right to education, and the right to the enjoyment of the highest attainable standard of physical and mental health. Now, the socioeconomic rights are different from the civil and political rights in that the obligations of government is that they must respect, protect, and fulfill these rights. In other words, they should refrain from interfering with one's enjoyment of the right. They should prevent others from interfering, and they should, over time, have a plan for ensuring that there is full realization of the right. And the general comment of the relevant committee is that retrogressive measures such as detention require very careful consideration and need to be fully justified in reference to the totality of the rights. And so, just as in our constitution, we have section 36 in international law, we have the Syracuse principles, which says that any limitation of rights must be based on a legitimate objective, must be strictly necessary, must be least restrictive, and not arbitrary, unreasonable, or discriminatory. So our argument is that the use of the coercive power of the state, and by this we mean armed police being able to arrest and detain people, must be, inevitably has consequences on their right to freedom, but also has serious socioeconomic consequences. And in all the countries in which we work as ACJR, the one common denominator that poor people have is their freedom to move around, their freedom to move, and that is how they survive, and selling things and offering their employment for work. And so when that is taken away, it has serious consequences, not only on the person themselves, but also their families and other dependents. Yes, detention before impending trial is sometimes justifiable, but we found in our work that deprivation of liberty almost inevitably interferes with the ability of individuals to be agents of their own development. And states which seek to maximize developments should really limit the conditions under which deprivation of liberty is lawful, and seek to reduce the total number of instances of that deprivation. So when we look at the lockdown, it was the case that many actions which would ordinarily have been considered to be normal were in fact criminalized. And often it was very carefully couched. So for example, not wearing a mask, it wasn't the act of not wearing a mask that was criminalized, but it was the refusal to do so after being asked to do that, to wear the mask by a police officer, that was criminalized. But it was the case that very many, particularly in the hard lockdown, very many very ordinary activities, such as leaving one's home, walking in the street, became criminalized. And so what are the objectives of criminalization? So the normal objectives of criminalization are that you incapacitate someone from harming others, the idea being that people leaving their homes would perhaps infect others. Unfortunately, what we saw is that what the provision of criminalization did was it increased the interactions between people and police. It resulted in people being arrested and detained, even for sometimes for a short while in a police van or in a police station, but in some instances longer, even in prison. And we'll see the data on that later. Then the other normal underpinning objective of criminalization is that rehabilitation. But we find that across the work that we've done in Africa is that changes in behavior are not driven by the fact that something is a crime, particularly in the South African context. Non-coercive interventions such as public education are generally far more effective in rehabilitating people. And then another objective of criminalization is often retribution. So there is some sort of moral blameworthiness to the conduct. Now, with the regulations changing so often and so frequently, and many people not understanding some of the regulations or finding them irrational and unreasonable, could there be any blameworthiness, and was there a guilty mind amongst those people, which is usually a requirement for a crime to be found. And then finally, the deterrence, the threat of criminal sanctions would prevent people from taking unreasonable risk. Again, in our work across Africa, we find that criminal law is not a likely vehicle for deterring behavior, and that behavior that is actually driven by emotions such as hunger or desperation or despair is very difficult to prevent using the criminal law and the criminal justice system processes. So alternative interventions which focus on personal responsibility are much more likely to have a sustainable impact. And so when we have a look, what did lockdown actually do? As our previous speakers have alluded to, so actions which previously would have been considered normal became criminalized. And for many people, income earning activity was criminalized. And this is particularly the case with the very poor, who, as I alluded to before, often only have their freedom to sell, their freedom to offer labor or to offer goods for purchase. And that became criminal in order to do so. And that is possibly, and in terms of mitigatory activities, a large group of those people would not have qualified for any of the support offered by government. And here I'm particularly thinking in particular of foreign nationals who would not have been able to get support through those processes. Now, those people would have had to survive through the kindness of neighbors, friends, and perhaps employers. And the longer that lockdown or those kind of conditions continue, the more difficult that was. On top of that, these criminal offences were enforced by police and the defence force, and we actually saw them carrying the semi-automatic rifles. And there were many incidents of abusive and indeed lethal policing of lockdown infringements that occurred. So if we see only in the very short period, only from 26th of March to 17th April, of the offences that were reported to IPID. Now we know that not every case actually makes its way to IPID, so we must consider these to be a minimum incidence. So 403 cases in that short period were reported to IPID, which represents a 12% increase on the previous year, even though we know that almost everybody was required to be inside, and there was in fact very little ordinary crime happening where police would normally be involved in conflict or in policing. And almost half of those were directly related to lockdown infringements, and indeed 5 deaths that we know of as a result of police action just in that very short time period. What we also have some insight in as to what happened to people who were not only accosted by the police, but actually went to court. And for this, we have only 3 days of data. This appears from the annual report of the National Prosecuting Authority, and they provide some insight. In only 3 days, we have over 2,500 people were arrested. Some were immediately released on warning. However, there would still have been an interaction that occurred. Some were released. Released is released immediately on warning, the court would have done, and bail would have been a full-on court process which occurred, but a good 16 or 17% were actually retained in custody for disaster management infringements. And according to other data that I've seen, the vast majority of these were around income earning activity, such as selling cigarettes such as, and in fact, the vast majority were around leaving your residence without a good reason. And then we have the minister providing us with further data where we had as many as 118,000 people arrested during the hard lockdown, and even more during level 4, arrested and charged, 230,000. And if you work that out against the working age population of around 39 million people, it's about 0.8% of the working age population were arrested over that time, almost 1%. Now, the reason this is of concern is, even if we say that criminalization was necessary as a tactic to prevent COVID-19, it may have backfired in quite an interesting way, in that if people were detained on remand, as we know they were, and you can see the red line is the line for 2020, and we see that bump in April, May, June, this is only the Western Cape because we only have data from the Western Cape. And what we saw happening is that people were flowing into remand, but not flowing out. Now, this is partly a result of court cases coming to a halt, but we know that bail applications were prioritized. So if the bail application was being made, that would be prioritized. But we see that this rise occurring, and now we know that remand is a dynamic population. So people come in, and people go out. In terms of COVID-19, we would have been people brought into a confined space, kept for a period of time, and then released out back into their communities. And it's interesting to note that the peak in the Western Cape of COVID-19 was just after that May peak that we see in remand detention in June. Then if we look at, then we can see the trend is even more pronounced and corresponds very closely to the hard lockdown and level 4 as well, the increase in remand detention. At the same time, this had a devastating impact on employment. There are very many ways to talk about unemployment. I think the most revealing one is the percent of the working age population which is employed. And we see a massive drop. These are September of each year figures since 2000. And so we dropped below 40% for the first time since 2000 to 37.5% of the working age population employed in some income earning activity by September 2020. It only rose slightly to 38 in December. Interestingly, if you look at the other data from Stats SA, the only sector of the population which managed to increase its employment was the laptop class of professionals. Every other sector saw massive reductions in the 100,000s in their employment. And then now just to look at the trends in terms of deaths over time, we need to remember that South Africa is a relatively volatile place in terms of mortality. We had a huge increase over the time of the HIV/AIDS epidemic, and that is around 2005, 2006, and that is also reflected in the correctional population. And Lukas will be talking about the measures taken in prisons to try to reduce that impact. And what we see is actually a relatively small increase in 2020 in terms of the natural deaths in prisons, compared to the very sharp increase with HIV/AIDS in prisons, which relates partly to the age profile, I believe, of prisoners. And so using the criminal justice system to enforce public health interventions, in particular in COVID-19, clearly infringes rights. And this may not be reasonable and justifiable because of the unequal impact, the disproportionalities, and the fact that it is irrational in a sense, as may have acted as a vectors for spreading the virus through increased contact between enforcers and the public, and the use of the custodial options, and the fact that the remand population is dynamic. And in terms of our limited prison spaces, it's clearly unsustainable to use criminal justice system processes to advance public health goals. And Lukas will be taking us through the what the government tried to do in terms of correctional centres.
Thank you, Jean. I think your presentation is very full in that it showed us the numbers, because it's very easy to believe, well, you know, this is in the air, but when you see numbers, it's really easier to grasp. As you've pointed out, Lukas will be focusing on prisons. I will give him the mic right away so that we can move on with our program. We do have a question and answer session. Once again, I encourage all participants to put your question or comments in the chat box. But for now, let us go to Professor Muntingh.
Thank you, Janelle. I'm just looking for my presentation now, which seems to have disappeared. Just indulge me for a second. I think there we are. So whilst that is loading, there we are. So, as noted, I'll be talking around prisons, the topic I'm probably most associated with, and I'm going to start off with the French sociologist Michel Foucault, who called prisons a detestable solution, but one that we cannot seem to do without. And I think that is the unenviable position that we find ourselves in, that we have to deal in one way or the other with this detestable solution. And prisons in the context of a pandemic presents a very particular case, and I'm sure Leandri would have a lot to add to it, but it is this high concentration of people that is the most important variable. Now, our law says that each prisoner must have at least 3.344 square meters available per person. Now, that's a very small space. It's pretty much as large as, a little bit bigger than a single bed. But that is often not complied with, and so we have prisons that are overcrowded, especially in the awaiting trial sections. So I'm going to make a few brief observations and comments reflecting on the past year. And I think the previous speakers have already raised a number of important thematic issues. And so the first major thing that I think one can lift from this is that what further restrictions are reasonable within a prison environment, if we're talking in the context of infectious disease. But it's also that there's an acknowledged duty of care by the state, and our jurisprudence points to an even higher duty of care with regards to prisoners. And how is that then balanced with the individual rights of prisoners and the rights that they are afforded under the Bill of Rights? So I think those are interesting issues. But let me get started on the presentation. If you're South African, you would probably know that our prison system falls under, it's a national competency, so it falls under one minister. And I think in a way that was an asset. That it did not involve the provinces in any meaningful way. But nonetheless, the prison as the closed institution had become even more closed during the hard lockdown, and this had significant implications with regards to prisoners' rights, with reference to access to a lawyer, the ability to challenge the custody, the extent to which the right to a speedy trial was possible, their access to external complaints mechanism, and very importantly, the ability to maintain family contact. I think at the outset, I also want to emphasize that in this work and many of our other work in South Africa, there is a real scarcity of quantitative information. And this makes it difficult to make proper policy recommendations. So I'll look at what was the impact on the prison system, but also how the state responded and what the results were of these. And then I'll raise a few issues for further discussion. So just by way of reminding us where we come from, these are the dates for the various levels of the lockdown, and it's in particular from 27th of March 2020 until the 31st of May that we had the most severe restrictions in the country, and consequently on the criminal justice system and prisons. So by all accounts, the criminal justice system came to a standstill. Whether that meant trials or bail applications, the default position was really a case of all matters must be postponed to a later date. And such postponement could be in person or audiovisual link-up or even in absentia. So for a period of 2 months, everything was put on ice as with regards to the criminal justice system. But as Jean already showed, there were continued arrests, so the inflow didn't stop, although there were different ways of managing that, and she showed us a pie chart on that. With regards to the impact on the prison system itself, there's often a perception that a prison is an entirely closed entity. But the fact is that there's lots of movement in and out of a prison on a daily basis. There's not only under normal circumstances suspects that must go to appear in court. There's also transfer between prisoners. Every day there are visitors that come to visit friends or family who are at that particular prisons. And then there are the officials, and there are 3 shift changes a day. So they move in and out, and it's important to note that they move from the inner secure sections of a prison back out into the community. So they are important in terms of that movement. And then there are service providers, not only private companies that render services to correctional services, but also non-governmental organizations who render services to prisoners, NGOs, and religious organizations, and so on. And then the other very important entity is the Judicial Inspectorate for Correctional Services and the independent correctional center visitors, or the lay visitors that are active at each and every prison in the country, some 235 prisons, where they take requests and complaints from prisoners and deal with this in terms of their own mechanisms. So this was abruptly stopped, this movement this was abruptly stopped, and then the relaxation of that only started in June with the move to level 3. In terms of the actual impact on staff and prisoners, and that is indicated there. These are the data for 22 March, and by and large, the impact has been fairly limited, especially in terms of the infections and deaths as well. So So in effect, with level 4 and 5, all visits by families, lawyers, the ICCV service providers stopped. And I think we have to acknowledge the importance and the value of outsiders being present in a prison on a daily basis is an important fact in terms of entrenching a culture of transparency, to have these external people there on a daily basis. But as a result of the lockdown, DCS stopped all internal rehabilitation, recreational, and educational programs. So my guess is that prisoners were by and large restricted to their cells 23 hours a day, and were let out for meals and the obligatory 1 hour per day exercise outside. But this obviously requires far more detailed research and monitoring. I think the lockdown also had an important impact on the prison economy, and one can now argue about the legalities of contraband and so on. Be that as it may, there's a good reason to believe that the restriction on visits increased the demand for cell phones, which are illegal in our prisons, but also the ban on cigarettes, which is an important commodity in the prison economy, also added to stress and conflict. And there were numerous complaints of that, and there were also some minor protests, and I think we can be very thankful that those didn't escalate to anything bigger. So, and then with regards to oversight and monitoring of the prison system, the unfortunate development was that the Judicial Inspectorate and its ICCVs were not defined as essential services when the regulations were issued, and so they were excluded from performing their duties. And I think it's quite a concerning development that such an important function has been written out in law. And it only restarted in mid-June 2020. Now, South Africa ratified the optional protocol to the Convention Against Torture in 2019, and the Human Rights Commission was designated as the coordinating structure for the National Preventive Mechanism under OPCAT. But that didn't really get off the ground. So the importance of that, I think, is significant, that here was an entity that is supposed to monitor conditions of detention that did not do that, even though it's obliged to under international law. We also know that judges, members of parliament and magistrates are mandated in law to monitor prisons and other places of detention. It's unknown if they actually did visit such places during the lockdown. I think it's highly unlikely that it happened. And then Parliament in general, Nico's already made the point that there was no formal role for Parliament, and questions must be asked on to what extent Parliament was consulted on the regulations and the ensuing directives, but also the role of Parliament in overseeing what was happening inside prisons, but also other places of custody. Interestingly, the Department of Correctional Services developed a set of standing operating procedures for dealing with COVID. And this they did by 16 March 2020, so 10 days before the lockdown, but it was only presented to Parliament more than a month later. The interesting thing about these standard operating procedures is that they focused exclusively on health issues and did not balance it with other human rights concerns, for example, access to a complaints mechanism or lodging criminal cases against officials or access to families. Any of those things were not dealt with in the standard operating procedure. So What was the response? Shortly before the lockdown, the Subcommittee for the Prevention of Torture that oversees the optional protocol to the convention issued a public advice to all national preventive mechanisms, including the South African one, and emphasized that a lockdown should not prevent monitoring from continuing. And it gave guidelines in this regard. As I've said previously, this is exactly the opposite that happened, is that monitoring ceased. So the SPT emphasized reducing prison overcrowding and maintaining normalcy as far as possible. It asked for compensatory measures, especially with regards to family visits, that prisoners should have access or increased access to phones, email, internet, and so forth. Of course, email and internet is not a possibility for South African prisoners, although the phones are, but whether they actually got increased access is unknown. So it then appears that the government took the other route to rather decongest, and after the minister told Parliament that social distancing is not possible in an overcrowded prison, they announced a remission of sentence for some 19,000 prisoners. And that came on the back of an earlier remission of sentence in December 2019. That saw the announced release of 15,900. It's uncertain to what extent this was actually implemented. We know from the Western Cape data that there was a decline in the number of sentenced people, but we don't know whether that is also the case for the other provinces. So it's a bit of an unknown. Nonetheless, both remissions excluded serious offences, as listed there, but it did not exclude assault with intent to cause grievous bodily harm and common assault. But a very interesting and for me concerning provision in the directives to facilitate the remission of sentence was that when the president announced it, it provided for a 5-year window period. In other words, any person whose scheduled parole consideration date would come up within the next 5 years could now be considered for parole. And I found one case, and these extreme cases do come to the surface. There may have been other less extreme cases. It doesn't mean that they are less worrying. But this was a particular individual who received a 9-year sentence for fraud involving 4.6 million rand. She started serving her sentence in February 2020. And so she just made this 5-year window period because a 9-year sentence would have meant 4.5 years have to be served. And she had already served some months, so it just fell within. And so in the end, she received a date in July for release in November 2020. So of the 9-year sentence, it effectively meant that she would have served 9 months. I do not know whether she was in the end released, but that was as it was reported at the time. So if we then look at the impact of the release, we then see that if we look at the numbers of prisoners on the 30th of March 2020, we had just 154,000, of which 102,000 were sentenced. By February this year, we had a total prison population of 142,000 and 92,000 sentenced. So in effect, the net gain was 10.4% for sentenced prisoners. So it doesn't appear as if the planned 20,000 releases took place. But I must hasten to add that we don't know what the normal releases would have been and what have been the intake of the system. So it becomes a bit of a juggling exercise to say, well, was the 19,000 in fact released? Nonetheless, let's move on. So as I already noted, that JICs were prevented from performing his monitoring duties, and this was only relaxed in mid-June 2020. There was, however, a coalition of NGOs, the Detention Justice Forum, that coordinate the monitoring of prisons and other places based on available information, according to the guidelines on the public advice from, and that's not the NPA, it's the SPT, the Subcommittee on the Prevention of Torture. And the forum submitted 3 reports to the Human Rights Commission as the NPM coordinating structure, and there was no reply from the Human Rights Commission, although JICs did respond with factual information on the monitoring report. The impact on JICs' work was severely restricted as a result of the lockdown, and the table there shows that in terms of complaints to the independent, to the inspecting judge, there was a decline of 77%. In terms of complaints to ICCV, there was a decline of 98%. But despite the problems with mandatory reporting, because segregation falls under that, there was an increase in the use of segregation of 52%. But very worryingly, there was an increase of near doubling of reports concerning the use of force. So I think it does tell us that this was reported by DCS to the inspecting judge. I think it does tell us that there were unusual levels of stress in our prison system. So by September 2020, there was approach to normalization, and there were now 1 non-contact visit per month, non-contact consultations with legal practitioners, and so on. I'm not going to go through the whole list. And ultimately, JICs could resume their duties. So, by way of conclusion, I think there are a number of issues if we're talking about the balancing of rights. The first issue was then the closing down of oversight, where monitoring and oversight was prevented in law, but we also had the failure of the National Preventive Mechanism under OPCAT to mobilize and provide guidance to the other entities that form part of the National Preventive Mechanism, which includes the Military Ombudsman and the Health Ombudsman, but also IPIT. That did not get off the ground. I think we were very fortunate that the protests that there were contained and that they did not escalate to anything more. That may not remain the situation if we were to go into a tighter lockdown again. I think it's essential that there must be transparency about the prison system. The Judicial Inspectorate should not again be restricted in performing its work. Communication with the prison population is essential to prevent the recurrence of the large-scale riots of 1994 around the election and the possible amnesty that resulted in the death of 36 prisoners. I think there was also executive overreach into the domain of the judiciary with particular reference to the what I call the 5-year window period for the remission of sentence, and that such a drastic intervention is possibly overreach by the executive, and I think it's very harmful to the integrity and the trust in the courts when somebody serves 9 months of a 9-year prison sentence for fairly serious crimes, such as fraud involving millions of rands. The third issue is the exclusion of civil society, and the case remains that there's no formal platform for dialogue between correctional services, the judicial inspectorate, and civil society. There is a possibility under the Section 11 Committee of the Human Rights Commission on torture, but that seems to be erratic in its meetings and not a constant force. And then the last point that I've already made earlier is the lack of accurate and disaggregated data. And again, the lockdown, or let me put it other way around, transparency was a real victim of the lockdown. And when monitoring conditions of detention, it is important that one gets accurate and reliable information promptly. And this was simply just not happening, especially during levels 4 and 5. And that is something that we should not allow again. But thank you very much.
Thank you very much, Professor Muntingh. I think we are now at a point where we are going to address some questions or comments. All the speakers gave us very interesting insights and inputs on the lockdown, on the various aspects that were affected. I want to go to the chat box. There have been a few questions or comments that have been coming in. The first in particular that is addressed to Professor Steytler, and this question is with regards to the Minister of COGTA. The question is that it's obvious that government has overreached and regularly made regulations that were not supported by science or even their own MAC. And this had made the situation, or has made the situation in our country worse than it could have been. The question then is, can the government, and especially the Minister of COGTA, be held accountable for what they have done? Professor Steytler, what are your views concerning this question?
Okay, first the question is, what is understood by being held accountable? Clearly, it's used in different ways. We can say, is the minister held accountable in Parliament? Yes, there can be questions asked. We can use the usual parliamentary processes of holding the minister accountable, but it is a political process. Are there other ways in holding a person or the minister accountable? Now, one can say, can they be held legally accountable for injury done? So if a person is arrested and there was no cause for the arrest, or it was badly executed, or for no good reason, the time was perfectly 6 o'clock, and it was arrested within the open period, then clearly there could be an individual case of wrongful arrest. If a more broader attack is launched to say, well, I was arrested after 6, but the 6 o'clock lockdown rule was irrational, then you have to take that on review, and that the regulation, whether it's contrary to the medical science or whatever, is here nor there. You have to say, well, this rule is in fact unlawful, and therefore any arrest under that under that measure, under that law, it will be also unlawful. So it's not an easy task, and as I said, courts are not going to be likely to second guess what is the correct science, or what is the the decision. These are policy decisions. They're very hard policy decisions. And it's not just a question, I just made a comment earlier on, that you balance the rights of a person to the rights or to the broader object of preserving public health. It's much broader weighing up. It is the health of a community, and that is not weighed easily against an individual. It's not a case like I think said about a kidney of one person to another person. That's not the issue. It is broad policy issues. How do we weigh the general public health vis-a-vis the general public interest in saving livelihoods? And that balancing is a public choice. Obviously, there's a lot of stuff that you can do on particular aspects, and it's been very neatly set out in terms of police and in prisons, how you ameliorate the matter of policy, how rules can be changed, but then within and to improve policy making in this regard. Thanks.
Thank you, Prof. Very good answer to that. I see a question by Jean, and in fact, it's a question that I had as well for Dr. Leandri. As a medical practitioner, what has been your experience in terms of the spike of mental health issues? And I see Dr. Jean's question here goes along the same line in terms of expanding. I know in your presentation, you skipped through some slides because of time, but can you give us a little bit more insight on your input on mental health, the immediate, the macro, as well as the widening and long-term impact from the cases or the patients that you've seen?
Sure, thanks. Yeah, maybe I can just bring up one of the slides that I skipped over, and I think that might help explain it a bit better. So, yeah, so I think, if you think about the effects of COVID, the actual virus and the lockdown itself, I think we can all agree that there was a significant impact on people's mental health. And poor mental health has various consequences. So it influences people's workplace productivity to begin with, which obviously has eventual impact on the economy. Poor mental health also has direct links to person's overall health. So someone with another chronic illness like diabetes or HIV and a comorbid mental illness would be less likely to be adherent to their treatment, less likely to adhere to lifestyle advice. So for instance, if you're very depressed and perhaps you're diabetic and you need to exercise, just by virtue of being depressed, you're not going to get off your couch and go and exercise. So they're very direct links to people's overall health. And then, by extension, if there's a higher mental health burden and there's also a higher overall health burden, then there would be a higher burden on our healthcare system as a whole, which again has financial implications for, on a greater scale. And you get into this kind of cycle of socioeconomic distress, which again also has an influence on people's mental health, and it becomes a sort of downward negative spiral. So in my view, really, mental health sort of sits at the center of health in general. And obviously you need healthy people to be productive, to be functional in their societies, and to contribute to socioeconomic development. And in the absence of that, you can imagine all the sort of knock-on effects across society. Sorry, I'm just trying to find the button to stop sharing the screen. There we go.
Thank you, Doc. I wonder, and I'm going to, okay, I see a question coming through from Kotso, and this is open to anyone, so feel free. How did the lockdown regulations affect the rights of employees in South Africa, with specific reference to retrenchment? Obviously, this is a socioeconomic impact, as Professor Steytler highlighted. Let us see if there's a follow-up question. Okay, no follow-up question on that. But does anybody in the panel want to particularly address the issue of retrenchment? Because obviously, as everybody has pointed out, there have been very severe socioeconomic impacts on unemployment. And Jean, in your presentation, you focused on those unemployment numbers. Do you have anything in particular to say regarding that?
So I don't think the lockdown regulations affected the rights as such. What it would have done is create the conditions for businesses to fail and to have to resort to retrenchments in order to survive. And so in that sense, and we see that in almost all the industries, in the other set of reports that Statistics South Africa does on formal employment, we see hundreds of thousands of jobs missing from the data, with only the professional class being able to maintain and in fact increase the numbers of people employed. So the labor rights would have remained in place. As far as I'm aware, I don't think there was a particular regulation that it would have affected that. Nico may correct me. But the practicalities of the matter is that businesses would have failed and or would have been in dire straits, and would have been able to apply for support. In some situations, we know that not everybody was able to get the support that was available, and that may not have been sufficient to keep a business afloat without retrenchments occurring.
Thanks for your input, Jean. Does anybody else on the panel want to touch on that, or can we move on to the next question? Okay, Professor Muntingh.
Sorry, I'm not on that issue. I wanted to ask a question to Nico. Can I go ahead? It's about the role of Parliament, and as you pointed out, no direct role was given to Parliament, and I mean, I also made that observation to say, but the question then for me is how do we get Parliament involved in a situation like this, where time is of the essence and decisions need to be made quickly, but you can't also, I don't think it was correct to exclude Parliament entirely from the process. So where does that leave us then?
Well, Parliament does what Parliament can do, and obviously there has been criticism of Parliament, say just on the role it plays during the Zuma years on corruption, and that's clearly been brought out. Now, the only way that you mobilize Parliament is through civil society, demanding Parliament, asking, putting pressure, and that is the end, that Parliament represents society, and society must make sure that Parliament does its job. So you know, there's no immediate way of compelling Parliament to do anything other than you know, using the usual political mechanisms and processes to activate Parliament.
Thank you for that response, Prof. From one panelist to the other. We have a question from Emmanuel, and this is for Professor Muntingh with regards to prison. Perhaps you've had a chance to read the context of his question, but he has two main questions. And he says, can we give a reasonable time frame or period in which various rights can be suspended before we say it is unreasonable or irrational to continue suspending those rights? And then his follow-up question is something that you touched on about JICs not having Should JICs challenge the regulations that excluded them from being an essential service, particularly in the first few months of the lockdown, as you mentioned in your presentation?
Yeah, let me start with the second question in terms of challenging the regulations. So that was done, that's my understanding, and so the work of JICs could recommence in June under level 3. We've not gone back to level 4 and 5 yet, but I would assume that if we were to, that JICs would make very sure that they're not again excluded from essential services. I don't think there's an issue about the importance of their work and the importance of maintaining monitoring and oversight. One can speculate as to how and why it happened. Maybe it was just an oversight, a mistake. As with regards to a reasonable time frame for the suspension of rights, I think one, well, Leandri gave the answer in part in the sense of, what's the requirements, irreparable, irreversible, and intolerable. I think it's difficult to say that it can only be for 7 days or 7 weeks or whatever. I think one needs to look at the particular situation. In a prison environment where prisoners are entirely dependent on the state for everything, their family contact, their food, healthcare, one may need to be a bit more sensitive and a bit more rigorous and vigorous about how we define what is, when it is still repairable, reversible, and is still tolerable, if I can put it that way. Thank you.
Thank you so much. This is a question I think that the theme is recurring, and it's addressed to you, Professor Steytler, about whether a state of disaster was more appropriate rather than having declared a state of emergency, and whether parliamentary oversight should play more of an important role. I know you touched on this quite recently, maybe just a very brief answer to Ms. Peterson's question. And then if there's other questions along those lines or pressing questions, I would allow for that. Otherwise, I have one final question for all the panelists. Professor Steytler?
No, thanks. Interesting, across the world, and we did a study now of 18 federations, only 2 used the state of emergency. And the one was Argentina, which actually happened to be under a state of emergency by December 2019 for economic reasons. And the other one was Ethiopia, and you also referred to a number of African countries. In Ethiopia, it was used to share up politics, so it had nothing to do with the coronavirus pandemic. So the practice has been thus across the world that you use lesser measures than state of emergency. The only advantage of the state of emergency is that you directly get involved in Parliament. For example, in terms of our own Parliament, they had to approve state of emergency, and then 3 months later approve again, and if there's another extension, 60% majority would have been required. But if you can see in South Africa, that wouldn't have been a problem in terms of the ruling party. What would be the question is, Parliament still functions as Parliament, and therefore its oversight role is not diminished. It may not have been higher under the state of emergency, and so I don't think it would provide any extra levers. It may just simply have been worse in the sense of then the powers of national government would have been extended. The point would be is also state of emergency would allow suspension of rights, except if it's a very short list of non-derogable rights. And none of these non-derogable rights really affects the measures taken under the Disaster Management Act. Thanks.
Thank you, Prof. And on that note, I mean, I think in many countries across the world, and in Africa in particular, with continuous extensions of states of emergencies or states of disasters, obviously there is the fear of authoritarian creep and, you know, the willingness to keep extending for this purpose of not only focusing on the virus, but for other underhanded reasons as well. I see a question or comment here from Zona, and it says, how would the DMA be enforced across South Africa to ensure that it is not targeted at the vulnerable and poor? This seems to be something that is infringing on rights, especially in areas where social distancing is not possible. Do you refer to the Disaster Management Act, DMA? I suppose that is the case. Does anybody want to say something regarding the question by Zona? Panelists?
I'll give it a go. So it's not the Disaster Management Act itself that contains the restrictions. It's the regulations made and published and gazetted by the minister in terms of the Disaster Management Act. And so these regulations need to be developed as the least restrictive possible when we look at them. And they should focus on public education, on personal responsibility, and be a lot less about criminalizing conduct which has very little rational relation to the purpose of the objective. So it's about going back to the constitutional principles that Professor Steytler outlined and looking at each and every regulation and saying, does it meet the requirements of reasonableness, rationality, least restrictive means, and discarding those that do not, and proceeding from there. And I think there wasn't a clear enough focus on human rights and the extent to which they were being infringed. In fact, it's barely mentioned in any of the government departments, any of the government statements, and it's not explicitly addressed that we are doing the least restrictive means. We are reasonable. This is rational. This is what we need, and I think that is what would have reduced the impact, particularly on the vulnerable in our society.
Thanks, Jean. Professor Muntingh, I saw your hand up.
Just a very quick comment. Even if our legal framework is as least restrictive as Jean and Nico suggested, there's still a lot to be said about the actual quality of policing. In other words, what is it that the police do when they do enforcement, and how do they go about enforcing the law? And there were some serious, and there remain to be some very serious problems. And I don't think we should lose sight of that. And so it does go to broader issues and persistent problems within the police around accountability and investigating rights violations, and also effective oversight. So if we are talking about enforcement, it needs to take that broader picture of the practicalities and the level of training and a whole range of problems we are all familiar with. Thank you.
Thank you, Professor Muntingh. We are going slightly over time, and I apologize for that. But I want to ask one question to all the panelists. And obviously, at any anniversary, under normal circumstances, anniversary are good things. But as we've said today, this is an unwanted and a bad anniversary. But I mean, when we speak and we discuss these issues, we also then need to think about looking forward. What should happen looking forward? And in your respective presentations, obviously you spoke about different aspects, but my question then becomes, looking forward in your particular field or in your particular topic that you raised, what would a good story be And how can we take what has happened, all the unfortunate circumstances that have happened in 2020 and that is still happening, how can we take lessons from this in order to look forward into the future? What should be changed? What should be undone? I mean, in 2 minutes, and this will also be your brief closing statements, kindly just offer us some of your insights of what you think should the future look like, bearing in mind all the lessons that we've learned in the last year. I will begin with Dr. Hattingh, if that's okay by you, and then we will move and then close.
Thanks. Yeah, I think really just from a public health perspective, like I mentioned in my presentation, I think it's, I think if we, going forward, and if we were to face a similar challenge again in the future, I think we need to approach it with a stronger multidisciplinary approach. So from the beginning, not just bring in the infectious disease specialists, but also have people representing human rights law and ethics and environmental science and social science and psychology and all of those things. I know it can become too big and it can become too difficult then to make decisions, but I think it really is important to bring all those perspectives to the table, because it is such a complex problem with so many different consequences. And then the other very important thing, as I mentioned also, is that the context needs to be considered. The context in that specific country, in that specific society, is absolutely important. What works in one country is not necessarily going to be beneficial in another. And I think those probably, to me, would be the two key lessons to take forward from a public health perspective.
Thank you so much, Doc. Professor Steytler, do you have any final inputs to give?
Yeah, one that actually flows from Dr. Hattingh's point is the notion of differentiation. It's already started coming true at the end of last year, where only certain municipalities became higher restrictions, and that is the notion of avoiding disproportionality of impact, where it is not necessary to have the same tough rules in a rural area as opposed to a city or whatever the case may be, so that one actually don't use a very blunt instrument to try to hit the virus, but a very sort of agile and precise instrument to use it. And the law is there, provision is made for that. And then the question is obviously that both provinces and local governments must have a voice in when something must be used, what instrument should be used to combat the virus, given their specific conditions. Thanks.
Thank you, Prof. Steytler. Dr. Jean Redpath, any last comments from you?
So yeah, flowing from there, when restrictions are required in a differentiated, targeted way, to rely more on public health messaging and personal responsibility, rather than the police and the criminal justice system to enforce in a rigorous and often counterproductive way that might actually make the situation in relation to this particular virus worse. And also to take lessons from what we've learned about the virus, about who is vulnerable, how it's vulnerable, and to adjust as quickly as possible to the changing knowledge, and not just stick with ways of being and assume that certain measures are effective or ineffective.
Thank you, Dr. Jean. Professor Muntingh, any last words from your side?
It's difficult to add to what has already been said, so but let me try. I think picking up on what Jean said is we need to learn from evidence. We must not think this thing is gone and over. We must go and re-look at the data and what happened and see what we can lift from there. I fully agree with the approach of differentiation, and that we must move away from this one size fits all. It is really not done as any good. And then I think we need to think longer term. It's probably very likely that we will have a repetition of this. It may be something different, but we need to be more prepared for this in future. Thank you.
Thank you very much. With that, I'd like to thank our panelists for their inputs, their contribution to this webinar. I think all the viewers and participants have really appreciated your points of views and even your last statements about what we can learn from this. I think we then need to take this forward and continue to impact society as well as the decision makers in Parliament and across the country. I would also like to thank all our participants for joining us this morning, this afternoon. Thank you for your questions. Thank you for engaging with us. We really do not take this for granted that you take some time out of your Friday to come and join us. And with that as well, I'd like to thank our funders, the Sigrid Rousing Trust and the Open Society Foundation, for the support that they provide to us. And we wish to wish you a happy anniversary or not. Really hope that, you know, this virus will be over. As I mentioned earlier on, lots of people have lost family members, colleagues, and friends, and we really hope for a better future. So with that, I would like to thank you very much. Have a wonderful afternoon and a wonderful weekend. Thank you so much.
Thank you, Janelle.
Thank you and goodbye.